They were in Germantown. So, yeah. Well, the building's up like it's being really up. Yeah. That's elevators like this. Well, I still don't appreciate it. I said, the new elevators in the 18 levels. It's like, well, this is kind of creepy. You know, like I can't just, well, down all the way down. But yeah, in case something happens. Our elevator.
Sean, can you hear me?
When I was on this yesterday.
They didn't go to the sixth floor. Right.
Right, can you hear us okay?
Yeah, I can hear you, Sean.
Information to that building.
And then once you do that, oh, there you go. What you do?
So the arrows control the up, down, left, right, and Zoom is on. This is on the
I don't know why there were showers up there. Why?
That's really zoomed in. Yeah.
All right, everyone,
Here we
the
are.
meeting, everyone's been admitted. and The meeting will now start. The meeting is yours.
I'm bigger than I'm.
I know, we don't want to be that big. That's. Go to Nashville next time. If you all need anything, I'll be just down the hall. Sure.
Okay,
Thank you.
thank you.
Yeah.
All right, good morning, everyone. Welcome to the Friday, June 21st edition of the Advisory Commission of the Rules of Practice and Procedure. Let's begin if we could first by having the reporter take the roll.
Good morning, everyone.
Yeah.
Do not call your name, I mark you absent. I mean, I mark you present, so.
That'd be great.
Please let me know.
That'd be great. Are
And
we,
it's
I think
bad.
I may be going up to Cincinnati to catch a Reds game. I think the Yankees are in town up there, so yeah.
How old are
Donald
you?
Paparella.
My daughter turned 19 yesterday. And my
Michael
son
Carter.
is 17, so.
Hey, Lynn, you're not hold for a second. I think they can. I don't know.
Yes.
Yeah.
Wayne Ritchie, Mark Falk. Sarah Key. Representative Lambert. Oh, there's Sarah Key. Representative Lambert. Scott Sims. Alan Wade. Judge Greenholz. Jim Hivner.
Here.
Judge McGee. Judge Smith. I'm not sure about one.
We have 10. All right, we're going to take a brief recess so that I can round up another member to give us a quorum.
Oh, no. He was gonna join us, Caparella. I thought I did.
Okay.
Tim, this is Tim Michael. I'm not sure my name was called or not.
I marked you present. I saw you, Tim.
Oh, okay. Sorry.
I didn't see. No.
Sorry, my bad.
I called Doug, I have you marked present. We just have 10 and we need 11 for a quorum.
My bad. I appreciate
No,
it.
I appreciate you clarifying so much.
This is Michael Carter in Jackson. Did you register me being present?
No.
All right, I think we may have been, muted, so maybe that'll give us a note.
Perfect. So we're good.
We're
That's
good.
11. Okay.
Excellent. We have passed the first hurdle, everyone. Let's begin, if we could, by Justice Tarwater perhaps making any comments that he'd like to make, and then we'll go from there. Justice Tarwater, the floor is yours. Justice Tarwater, are you able to hear me?
You can-
I've had previous occasions where Supreme Court justices have not paid any attention to what I would say, but it's never happened in a Rules Commission meeting. Oh, okay,
I think there's some audio.
there's an audio issue. All right. This is our first time back in conference rooms in 4 years.
Maybe now.
Okay. Good morning, Justice Tarwater. Are you able to hear me?
Yeah, I want you to know that. I really- I gotta figure out this.
Even better.
Looks. Wrong, but. There we are. Yeah.
Okay, good morning. We like to start, Justice Tarwater, by just giving you the floor and having you make any comments or introductions you'd like to make today.
I don't think he can hear you.
We are not hearing anything. Are y'all hearing us?
Yes.
Gino, can you hear us?
Yes, we can hear you, Justice.
Okay,
Great. Well, we've established a quorum, Justice Tarwater, and so we're going to dive in after we just give you the floor for a moment if you would like to make whatever comments or introductions you'd like to today.
sure. Well, as you can see, the Knoxville contingency is a bit thin, but I have Judge Greenholz here with me and Wayne Ritchie. Mr. Chairman, I apologize that I need to bust your agenda just a little bit. Chief Justice Kirby has asked me to lead a project and has asked the Rules Commission to help us. And this just came about within the last few days. So I apologize. I apologize, Lynn, for not getting this on the agenda. But essentially here is what the issue is. In these days of electronic filing and internet access, the court had, in both of the courts of appeal and the Supreme Court have gotten requests for copies of briefs that have been filed in cases, and occasionally requests for the record. And the clerk's office does a really good job of responding to those, although can be somewhat labor intensive and it can take some time. So the court is considering providing access to the filings online. And we think that would benefit the practice and would also benefit the courts. The problem with that is that in many of the cases, there is confidential information that is contained in the briefs for the record. And in order to effectively do this, we probably need a rule on redaction policies. Well, first of all, we have to determine who's going to be responsible for the redactions. And we probably need a rule on the redaction policy. And then administratively, the AOC is going to have a job to do on determining how to provide access to the filings in the cases, the briefs, importantly, and then how far back that's going to go and that kind of thing. So Chief Justice Kirby asked me to chair a task force to look at this issue. and also asked me if the Rules Commission would help us. And so that is my agenda busting item, for today. We would like the support of the commission, and what I would like to do, with your permission, Mr. Chairman, and we can talk about it offline if you want to, or I can do this today, but I would like to name about, in addition to me, maybe 4 or 5 of our number to work with me and figure out how we can get this done. Including, proposing a rule that has a redaction policy in it. There are a number of appellate courts that have redaction policies. And in fact, there are a lot of trial courts in our state that have redaction policies. And so the time has come for us to make our filings available online. So that is the ask of the court today. With your permission, I would like to, and I can discuss this with you offline, or I can just do it, but seek some volunteers to help me on this task force. The court would like for this to be accomplished by September, not obviously, we would have to go through the rule making process, put the rule out for comment, but we would like to start the discussion so that we have a week-long work session in September, and we would like to be able to consider it then. So that's my ask, and my apologies. I guess it's, as you know, it's sometimes better to ask for forgiveness than permission.
Well, to the extent that you need a justice, the forgiveness is there. There's no problem there. And I think historically with our committees, they tended to work better when they're staffed with volunteers versus draftees. So if it's okay with you, Justice Tarwater, why don't we just at this point ask who would volunteer to participate with Justice Tarwater on the task force for which he has been assigned the chairmanship.
So Jim Hifner doesn't know it, but he's volunteered.
Okay.
And Judge Greenholz has also volunteered, although he didn't know it until just then, so.
Who was the second volunteer? Oh, thank you, Judge Greenholz. I appreciate that. So we've got 2 of the 5 seats.
Gino, this is Tim Michael. I'll be happy to do it as chair of the Appellate Rules Committee.
Wonderful, that's 3. With your permission, Justice Tarwater, I'd be delighted to be on the committee as well.
That'd be great.
That'll give us 4.
I'll volunteer too.
All right.
That Andre?
We have a
Yes.
former Solicitor General of the state of Tennessee. Seated right here.
I was gonna ask, but not put her on the spot if she would do it with us. She's such a valued member of our appellate committee.
Well, she was gonna get a call from me after this meeting, and to ask her to volunteer in much the same way Judge Greenholz just volunteered. I think that's a group, right? So that's me, Tim, Gino, Judge Greenholz, Andre, and Jim Hifner.
Yes.
All right, that's our group. Thank you, and you all will hear from me, and we'll set up something and figure out how to tackle all this. It's a more complicated issue than you might think.
But definitely a worthwhile one. Let's move, if we could, then to what is now the second item on our agenda, approval of the minutes. They've been circulated, obviously, by the reporter. Can I have a motion for approval of the minutes? Okay, thank you. I need a second.
I'll second.
Okay, thank you, Andre. We got a motion and a second. Any discussion or comments or revisions to the minutes? I see none. So let's go ahead and just vote by voice. All in favor of approving the minutes as distributed, please say aye.
Aye.
Any opposed, please say nay. Great, okay, the minutes are approved without dissent. The next item, which is action item number 3 on our agenda, concerns another matter on which we're going to vote today, which is the proposed revisions to Criminal Rule 24F and Civil Rule 47.02. This obviously concerns the discharge of alternate or additional jurors once a jury has retired to deliberate a verdict in either a civil or a criminal case. Many of you will recall that this is something that Judge Parks from Murray County brought to us in our meeting in March. And the problem that's been identified is this. It's not one that arises frequently, but on occasion, after a jury has retired to consider its verdict, one or more jurors will fail to show up for duty or have to be discharged for some reason. And under the current rules, when that happens, the only result is a mistrial, because under current Criminal Rule 24F and current Civil Rule 47.02, the additional and the alternate jurors are discharged once the jury retires to consider its verdict. The proposal before the commission today is to revise both the criminal rule and the civil rule to allow a court, in the court's discretion, to retain one or more additional or alternate jurors when the jury retires to deliberate its verdict, in the event that a juror becomes ill or has to be discharged for some other reason. And if you can look at pages 13 and 14 of your packet of materials, you'll see that the ad hoc committee that we have appointed to review this issue has come up with proposed changes both to Rule 24F and to Rule 47.02. And looking first at page 13, the revisions are fairly evident. The proposal is to remove the last line of subsection 2A, which currently states that a juror who is not selected as a member of the deliberating jury shall be discharged when the jury retires, and also striking the last sentence of subsection 2B, which provides similarly that an alternate juror who does not replace a regular juror will be discharged. Both those sentences are coming out, and we're adding a new subsection 3, subsection 24F3 it will become, that says regardless of which method a court takes in constituting the final jury, I should say, the court has the discretion to allow one or more alternate jurors to remain. And the court has to ensure that each additional alternate juror who's retained not to discuss the case with anyone until that alternate or additional juror replaces a juror that has been discharged. And then once the court, in its discretion, replaces an excused juror with an alternate or additional juror, then deliberations have to begin anew. That is, from the very beginning, that newly reconstituted jury has to begin deliberations just as though they were discharged from the courtroom to deliberate the verdict in the first instance. And when you look at page 14 of 14, you can see that we've made identical proposed revisions to Rule 47.02, the civil component, that just deletes the last sentence of subsections 1 and 2, and similarly adds a new subsection 3, which simply says a court may retain additional or alternate jurors, and then goes through the same process that you have to make sure that the retained jurors do not discuss the case with anyone until that juror is made part of the jury, and then the deliberations have to begin anew. And I can point out that the changes that we are proposing here to these rules mirror the practice in federal court under Federal Rule 24C, which has had this practice in place for a significant period of time. And so those are the proposed changes that the ad hoc subcommittee has come up with. And before I ask for a motion for approval, let me ask Alex Little, who was a major part of these revisions, whether he's got any additional comments or clarifications to what I've just laid out. Alex?
I don't know if you can hear me, Gina. I just, hopefully you can. I'm just on the phone.
Yes.
No, I have no further comments. I will say this federal rule has worked fairly easily. It's not particularly controversial in the federal courts when it's used. And this mechanism, especially for large trials and long trials, to give the judge the discretion to do this is, I think, really important to protect against mistrials and having to do it over again. And I will say nothing about this mandates that the court do it. If the court thinks, I want to send the jury alternates home, but we're not going to use them, I'm okay with that. That discretion remains with the trial judge at all times.
Great. Thank you, Alex. Given those comments and that introductory explanation of the proposed rule, can I have a motion for adoption of the proposed revisions to Criminal Rule 24F and Civil Rule 47.02?
So moved.
Okay, thank you. Sarah, can I have a second?
Second.
Thank you, Captain David O'Neill. We have a motion and a second. So the floor is open for discussion. Do we have discussion on these proposed revisions? Yes, Justice Jarwater.
Yeah, Mr. Chairman, I just have a question, and it just dawned on me when I looked at this. So if you look at Rule 47, 47 subparagraph 2, alternate jurors in the order in which they are called shall replace regular jurors who, prior to the time the jury retires to consider the verdict, become unable or disqualified. Okay, then in paragraph 3, it says the court may retain additional or alternate jurors after the jury retires to deliberate. And then it allows the court to replace the alternate, or it allows the court to replace the regular juror. Is it clear enough in the rule that the trial judge must replace the regular juror in the order in which they are called? So if there's going to be a replacement, is it going to be alternate number 1? Or does the trial judge, is it clear that it's alternate number 1 and that the trial judge does not have discretion to pick, okay, I'm going to replace juror number 10 with alternate number 4? Am I just looking for trouble here? I think it's pretty clear, because it seems to me that since they have to begin deliberations anew, then they have to retire again to consider the verdict. So it seems to be okay the way it is written, but I just raise that as an issue. I wouldn't want the trial judges to, even though they have discretion to replace the regular juror, they should do it in order, right? Is that clear enough from this?
Well, I think that's an excellent point, Justice Tarwater. It's not something that even we focused on during our discussions. But the issue you're raising will certainly arise if the court retains more than one juror. If a court were just to retain one additional juror or one alternate juror, it wouldn't be an issue. But if the court retains 2 additional jurors or 2 alternate jurors, then we have the issue that you're describing. And I think we could provide additional clarity if we just added a sentence to the end of paragraph C that says, in the event that the court retains more than one additional juror, the court shall choose the replacement juror by lot. in the event that the court retains more than one alternate juror, the court shall replace. But let me start that last one over. In the event the court retains more than one alternate juror, the alternate juror shall be placed on the jury in the order in which they were called. So we preserve the integrity of subsections 1 and 2. Yes.
Sure, that's a great,
Between-
that's a great solution. And when I was trying criminal cases, we used almost exclusively the single entity process under the criminal rules. So maybe up to Justice Starwater's point there, we don't have in a single entity designation of jurors being juror 1 and 2. So maybe, you know, your idea about drawing by lot might be an interesting way to go about it, because I may have 2 or 3 jurors, all of them were part of the entity before the discharge. Maybe in other words,
You know, can I make it?
at least in the criminal, on the criminal side where you have single entity jurors, it might not work as well there if we're picking them in the order in which they were called.
All right.
Gino,
Alex?
can I make a suggestion?
Yes, please.
I think this is already dealt with in both rules. If you look at, and all we have to do is cut a clause. So if you look at 24FB, it talks about the order, alternate jurors, and the order in which they are called shall replace jurors.
Mhm.
If we just delete prior to the time the jury retires to consider its verdict, I think that then makes clear that that sentence applies to any time you're going to use them as a replacement. Same issue with Rule 4702(2). You just delete the phrase in subsection 2 prior to the time the jury retires to consider its verdict. And so essentially the order of operations rule for the alternates in subsections 2 of 4702 and B of 24F would still apply before or after the jury retires.
Alex, how would you address it on the, when a criminal court judge is using the single entity? Do you draw by lot in that case, or how?
Well, I think the single entity though is we've never had sort of a rule about who gets to stay and who gets to go. I mean, I think it's always been left to the judge's discretion. They just do the lots. And so if they draw by lots and there's folks left over, I don't know that thinking about it from the context of why the parties would care. You know, if you have alternate jurors in certain order, you care about that when you're selecting the jury. When you're drawing by lots, you know that any of those jurors may be substantive juries on the actual panel that decides the case anyway. And so the same considerations of voir dire don't come into play. So I just don't know that it's an issue in the single entity jurors, where it certainly is an issue in the separate entity jurors.
It would become an issue if you had a trial judge that selected on her own which of the alternate jurors comes on to the deliberating jury. So let's say that you had 2 alternates and that you excluded them from the single entity as the jury goes to retire. You have a vacancy, and now it comes time to pick one of the alternates to fill that vacancy on the deliberating jury. If you have a trial judge that is picking that juror, you may run into questions then from the defendant after conviction about the trial judges putting the thumb on the scale.
So I totally agree with that. I think the way to deal with that is also in the rule where we have on subsection 2A of 24F, before the jury retires to consider its verdict. At that, I would say instead, when the jury is constituted, if we just change the language to when the jury is constituted, because that would then invoke the reconstitution. And so we can do less, make less edits by just changing that clause before the jury retires to consider its verdict to when the jury is constituted or reconstituted. And the same
We talked
change to
about that.
47021.
So Judge Greenhouse in Rule 24,
Yes, sir.
alternate jurors in the order in which they are called shall replace jurors who become unable to disqualify. Is
Right.
that, but you all, sounds like you do it by lot.
We did under 2A. So in Alex, I was thinking that at least in some cases, you may think that the jury under the single entity version is constituted upon swearing. And so at least the way we did it, we thought we were doing it consistently with the rule, but maybe not, is that, the jury of 14 people would preside over the entire time they've all been sworn. When we get ready to discharge the deliberating jury, we selected by lot 2 to come off. Under this proposal, I can keep those 2, maybe in a separate room. Then when I have a problem with my 12-person deliberating jury, I can select one of the alternates then to come back in. And the language here would be when I'm reconstituting the jury, I would also select it by lot.
Yeah, I'm just wondering whether if we use that phrase about when you do it before the jury retires to consider its verdict, and or if an alternate is required, just put the language there to show that that same sort of process should be conducted for the in either circumstance.
Judge Greenholz, this is Gino. Let me ask your thoughts about this, because this circumstance arises so rarely that we could probably get by with just having the rule say that the judge has the discretion to retain one additional juror or one alternate juror, which then sort of solves a problem that only occurs rarely and doesn't give a criminal defender or anyone else a reason to try to criticize a judge for selecting one replacement juror over the next. What are your thoughts about that?
I don't disagree with that at all. I think, my understanding from our meeting last time with Judge Parks was that he was thinking that he would like to have, in his first best world, an opportunity to have multiple, alternate jurors. I agree with you, though. I mean, in the entire time that I've tried cases, I had exactly only one case where I needed to use an alternate at all. So it certainly isn't, something that's going to come into play a lot. If you had a limitation in the criminal cases on retention of one alternate juror, I think that would solve it all.
So would that one alternate be chosen by lot?
By lot.
Among the alternates?
Or in the single entity, in this case of the 13, that person chosen by lot. And then if one of the 12 deliberating jurors goes out, then you replace it. Yeah. So, Mr. Chairman, I think that works well, at least in terms of avoiding the appearance of the judge putting the thumb on the scale or trying to pick a way in which the judge must select the alternate to now serve on the deliberating jury.
Alex, what are your thoughts about revising the rule just to say the court retains discretion to retain one juror?
Well, I think two things. One, I can imagine, although it's rare, that there may not be a need to limit us to one. If you've got you've got a trial in Georgia right now that's going for 18 months, and I could see if you have a very extensive trial, you may need more than one. But I don't know that it actually solves the judge's concern, because the issue is how do you select that one? And so if you started with a jury of 14, you drew lots to find the 12 on the single entity version, somebody still has to make the decision of which of the two who remain you choose as the alternate. And I think that's probably the bigger concern for the parties, is who gets to make that choice or how is that choice made. On the alternate order way, we know what that is. It's going to be the order they were assigned to be alternates. But I think any time you have more alternates that you start with, and you've got to retain a smaller number, somebody has to make the choices to who. And I can imagine that the parties could at least raise the concern if the judge is allowed to make that question. If it's by lot, I don't think it matters. But again, if it's by lot, then I also don't think that it matters if there's more than one retained. And to give the judge that ability, I think keeps the rule as flexible as possible while consistent with all the things we've talked about.
Well, I agree with that.
So is the idea that we could revise both the civil and the criminal rule to say that the judge selects the alternate or additional juror by lot?
You may only need it on
Yes.
the side. You may only need
It's,
it.
yeah, I don't know the civil side would be able to raise an issue. I think there would only be well, I guess there could be a due process issue. I would say mirroring them makes the most sense, and it would only apply to the single entity juror situation.
So if we were to add that language, Alex, do you have a proposal as to what it would be and where we would place it?
Sorry, Gina, my phone was on mute. Looking at it, I think it would be after that sentence as to how the lots are drawn at the close of the case. It would probably be a mirror image sentence that says the same things. You know, when a vacancy arises after the case is closed, the judge shall follow the same procedure. I would say something like that in both rules.
And you're saying add that to the end of paragraph 2A?
Yes, let me pull it up, make sure that's right. Yeah, that's exactly right. So I would say if a vacancy arises after the jury retires, the court shall select the retained alternate to serve on the jury in the same fashion or in the same manner.
Judge Greenholz, what are your thoughts about that approach?
I think that's an excellent suggestion.
And do you concur that we ought to add that language to the civil rule just so they continue to mirror one another?
You all have the advantage on me. It's been just a little while since I practiced in the civil law.
Okay,
As I'm reading Rule 47, though, we also have a single entity jury.
yes,
Yeah, then I think so. Yes.
Alex, could you give us that language one more time just to make sure we've got it down so we can ask Sarah whether she'll accept an amendment to her motion?
Yes, so at the end, starting with 24F, subsection 2A, the last sentence should read, if the vacancy arises after the jury retires, the judge shall select the retained juror to serve on the newly reconstituted jury in the same manner, period, because it follows the other description.
I would accept that as a friendly amendment.
Okay, Great.
Hey, Alex, can I make a suggestion to that? Just, instead of saying the judge, would you say can we say the court, because that would be consistent with the rest of the language?
Yes,
Thank you.
yes, certainly.
all right, let's, if
That mandatory language, can you give us that again?
The court shall select.
well, let's have Lynn read it
If the
back.
vacant-
The official minutes. Go ahead, Lynn.
Great. If the vacancy arises after the jury retires, the court will select the alternate to serve on the jury in the same manner.
Is that a will or a may?
He said A first and then B, so I don't know.
It probably needs to read if a vacancy.
Yeah, indefinite article.
Okay,
Right,
if a vacancy arises.
after the jury retires.
The court shall select the additional juror in the same manner.
Shall.
Yeah.
The
Yes,
court-
I think shall is consistent.
A replacement or an additional.
Okay,
We'll select an additional juror.
yes. In the same manner.
We're not gonna read it as the alternate. Okay.
Right, because it'd be the addition.
The additional juror.
Yeah, does that require? I guess the question we're having, or I'm having is, does that require trial judge to replace with an alternate? Or does he have the discretion then he or she still have the discretion?
I understood it to mean that they still have the discretion, but if they choose to add an alternate, this is the procedure they shall use.
The court may retain. And if the court does retain, then the court shall pick in this manner. I think that is
Yes, sir.
exactly what we need to in civil.
Maybe on both, yeah. Well, one question on the civil side is whether the court may want the ability to ask the parties if they would agree not to have to start the deliberations over, but just to go with the remaining jurors. Is that a consideration? In other words, you want to require the deliberations to start over with a new juror, or let the parties and the court, with the court's permission, agree to go forward with the remaining jurors?
I think they can still do that. And I don't know. Another good question. Did everybody hear the question?
My concern with not requiring them to begin deliberations anew is that there will be an argument about unanimity of the verdict. And so unless the judge actually
Well,
takes those verdicts immediately from the original jury, I don't know that we can have them just agree to start from X charge, whatever number charge or count there is.
I was speaking softly, so on the civil side, the question was just whether, let's say the judge retains one or two alternates,
Yeah,
deliberations start, and they go a day and a half, and then a juror gets sick. A deliberating juror gets sick. And do we want to allow the possibility that the parties, and with the court's permission, rather than having all the deliberations start over with the addition of an alternate, simply agree that the originally constituted jury, less the one that just got sick, could go ahead and conclude the deliberations without the alternate? Or is the substitution of an alternate going to be mandatory?
So this is Alex. I do think you can allow that, and I think the rule is meant to allow the discretion. And so if the new sentence is seen as the problem, I think you can sort of modify the preface to the newly added sentence with some language that suggests, in the event a vacancy arises that the court chooses to fill, which then would make clear that the court's option in the word may previously still exists.
Love that.
Sounds good.
does that address the concern, Wayne, or do you still have the same concern?
It does. Thank you.
Okay.
So then, this is Elizabeth, are we gonna have a different procedure in the civil rules? Because obviously in a criminal case, we can't do that. So.
Yes, I think that only applies to the civil rule.
Right, so that would have to be something different in rule 47.02.
Yeah, I think for the federal rule, for the criminal rule, it would read with the amendment we just sort of laid out and discussed. And I think on the civil rule, you would add that additional language in the clause to clarify that if the vacancy arises after the jury retires, if a vacancy arises after the jury retires, which the court chooses to fill, comma, then the language that we discussed.
All right, let me, if I could then just restate what I understand the amendment to be and see whether Sarah will accept this. The revision of the amendment to Rule 24F subsection 2A would be adding the following sentence to the end. If a vacancy arises after the jury retires, comma, the court shall select an additional juror in the same manner, period. Rule 47.02 subsection 1 would add the following sentence to the end. If a vacancy arises after the jury retires, which vacancy the court chooses to fill, comma, the court shall select an additional juror in the same manner, period. Close quote. Alex, is that what you're
Yes,
intending?
Yes, I would just not use the second word vacancy. I would just say which the court chooses to fill.
Okay, we'll take
Instead
the
of which
second
vacancy.
vacancy out. Sarah, is that acceptable as a friendly amendment?
Yes, sir.
All right. Do we have any other discussion on that amendment? Let's, if we could, then just vote by voice to add the amendment to Sarah's initial motion. All in favor of adding the amendment just read into the record, please indicate by saying aye.
Aye.
All opposed, nay. All right, there are no nays. So we're back on the motion as amended. We've got obviously the original motion that came from the ad hoc subcommittee, now modified by the amendment we just put on to subsection Criminal Rule 24F2A and Civil Rule 47.02 subsection 1. Do we have any further discussion on the motion as amended? Seeing none, let's, if we could, Lynn, go ahead then and take a roll call vote on the rule as amended.
Gino Volto,
Yes.
Catherine Barnett, Brandon Bass, Andre Blumstein.
Yes.
Jim Bowman,
Jim, you're on mute.
Thank you. Mr. Chairman, I tried to get your attention, but I obviously had something, I had some comments I wanted to make about the amendment, but if,
Oh, my apologies.
I think I was on the mute, but, if I may, I will though.
Please, go right ahead. We'll
Yeah.
suspend the vote for just a minute. Go ahead, Jim.
I'm speaking in opposition strictly to the amendment to Rule 24, the criminal segment. First of all, I've tried several hundred criminal cases to juries, including probably a dozen death penalty cases, which tend to be extended. Memory might fail me, but I've never had the problem in all of those trials of a juror having to be replaced once they retired. I've probably had a couple of situations that resulted in mistrials where there wasn't an alternate and somebody got sick or something. But in listening to this discussion, it doesn't appear to me that this is a huge problem statewide. I know that judges tell jurors that they should totally ignore evidence that they've heard, but which the court rules is irrelevant. I think that's usually a kind of a useless instruction, but the requirement here that at some point in time a juror has to be replaced, and the judge says, "Now I want you to put aside everything you've discussed and start completely over," is it's straining. I don't think it can be done. So since it's not a big problem, and since criminal cases call on issues that don't necessarily arise in a civil case, I'm opposed to creating a situation in which we're sent in. So
Okay.
so that's my point on, and that, as I say, that applies only to the Rule 24, not civil case. That's all.
Thank you, Jim. Does anyone have any comments in reaction to what Jim has just shared with us? All right. Well, seeing no further discussion, let's go ahead and start the roll call vote anew, just like we'd be starting jury deliberations anew if we had a place juror. We know how Jim's going to vote, but we're going to call him anyway. Let's start over, please, Mr. Porter.
Gina Balso.
Aye.
Andre Bonsley.
Yes.
Jim Bowman.
Jim, are you voting no?
Oh, no, sorry, I
Okay.
didn't understand.
Gotcha.
Bo Burke.
No.
Donald Caparella.
Aye.
Michael Carter.
Yes.
Mark Falk, City Join. Doug Hallahan.
Yes.
Aaron Hall is out. Sarah Key.
Yes.
Julian Kelly.
Aye.
Representative Lambert. Alex Little.
Yes.
Alex Little. Are you voting? You can come back.
I am. I was having audio trouble. Did you hear me say yes?
Yeah, I didn't, but thank you for clarifying. I have it now. Thank you.
Sorry.
Tim Michael,
Yes.
David O'Neill,
Yes.
Wayne Ritchie,
Yes.
Scott Sims, Alan Way,
Yes.
the ayes have it.
You didn't, Don Capital.
Did you get him in?
Don Capital.
I called him. He did. Donald Caparella.
I said aye.
Okay,
We're good.
thank you.
All right, the motion carries. Thank you all for your very good work on that one. The next item we've got on the agenda is discussion item number 4 pertaining to feedback from the commission members regarding proposed revisions to Rule 52.01 of the civil rules and Rule 3E of the appellate rules. Tim Michael, the floor is yours.
Yes, thank you, Chairman. The issue before the committee, and I will say that Justice Tarwater somewhat warned us that this might be an issue that sparks discordant viewpoints and debate, and we have found it to be. But the issue before the committee is whether Rule 5201 of the Tennessee Rules of Civil Procedure, or alternatively Rule 3E, and I will say or both as another alternative, be amended to require that after a bench trial, parties must first request additional findings of fact from the trial court before they can challenge the court's lack of factual findings on appeal. And this was a proposed amendment that came to us from Chancellor Tony Childress out in Dyersburg. And, you know, in looking at this initially, you know, there's the idea that this could be something that would be taken up in the rules of civil procedure or in the rules of appellate procedure. So I talked in our last meeting, we talked about getting the Rules of Civil Procedure Subcommittee also involved in this discussion. So Scott Sims, Doug Hallahan, and I have come together, discussed, put together a joint task force from both committees to address this issue. And following up on a suggestion by Justice Tarwater, we started calling and speaking with both the proponent of the change, which was, again, Chancellor Childress, and also some folks that had already spoken out in opposition of the change, which included Judge Clement. So we've had those we've had those initial conversations. We were moving toward a subcommittee meeting. We were talking about one of the questions that I personally had after having those initial conversations. And as you can imagine, right now, the trial judges seem to be very much in support of this rule. The appellate judges and Jim Hibner, I don't mean to speak for you, but Jim and I had a short conference. We caught each other between some meetings out at the Bar Association, a meeting in Memphis. And I think Jim said, he expressed to me privately, at least, I'm going to make it a little public, that he had some concerns about the changes or the proposal. One of the issues that came up initially in our conversations, and a concern that I had, is you've got really two separate situations at play in my mind. You've got the situation where the court itself determines sua sponte that the trial court hasn't made sufficient rulings in the record, whereupon the court determines that it has the inability to review and remands to the trial court. And then you've got this other situation, which in my mind would be the only one the proposed rule would address. And that is when one of the litigants makes that argument. And the rule would only require that would allow that litigant to only make that argument if and only if they had first requested, basically through some sort of motion, that the trial court make additional findings of fact and conclusions of law, I guess arguing to the court that it hadn't really done its job under Rule 52 in providing sufficient findings of fact. So one of the questions we had initially is, how often does this happen through the motion or the argument of a litigant versus whether the court sua sponte raising the issue? Because there was some concern about not wanting to do anything in the rules that invades the province of the court to determine whether something should be done versus whether it's something that a litigant argues. And I would think personally that the number of times that a litigant would be able to make this argument would be fairly limited, just based on sort of the logistics of how things play out. We had asked initially if there were any empirical information available from the AOC or from the clerk's office, kind of suggesting, a breakdown of how many times things actually get remanded, and just trying to make sure that we were not providing a remedy that had no, disease. And so in any event, we have found through our conversations that those sorts of numbers, that sort of empirical data is not readily available. And so we're just kind of going on anecdotal information and issues that trial judges have had in the past with this. The big gripe from the trial judges seems to be that, the matter goes up on appeal. The appellate court determines that there are not sufficient findings of fact in the record to support the ruling. The appeal gets dismissed on that basis, gets sent back to the trial court. The trial court then has to go through the process of doing what it needs to do to amend or supplement those findings of fact. And then the appeal process has to begin anew, completely de novo. And so some thoughts have been given that perhaps there ought to be some sort of mechanism in the rules or the procedures of the court so that the appeal itself doesn't have to start again and be de novo, because that creates, additional delays and creates additional expenses on behalf of the litigants. The dividing line there is, the appellate courts or some of the appellate court judges have taken the position that Rule 5201 was amended in 2009. It gives the trial court specific instructions on what need to be included in findings of fact. There is Supreme Court authority written by Justice Clark, 2013 in Lovelace, that actually goes through and very specifically sets out why trial judges need to make very specific findings of fact in bench trials. And there's some thought that it's essentially telling the trial judge to do his job yet again. The instruction is already there. Why aren't trial judges following that instruction? So those are sort of the two viewpoints that have been expressed. I think that the issue is a much deeper and a little bit politically sensitive issue than we normally have to deal with here. And so we are getting ready. We'd made a lot of good momentum. Then I had some personal family medical issues with my mother, which she's fine now, but kind of got us delayed. So we need to get back on track. But with the meeting coming up and with having the benefit of the committee, and I know Jim, like I said, Hivner, you had indicated you had some concerns. I would just like to, if possible, Mr. Chair, hear any concerns or thoughts that folks might have so that we'll have the benefit of those during our joint task force meetings.
Great, thank you, Tim. Would anyone like to react to Tim's presentation?
I probably lulled everyone to sleep, and I apologize. That was rather lengthy.
Not at all. All right, it doesn't appear that we have any comments, Tim, but thank you for your good work. It is a sensitive issue, and I appreciate your attention to it.
Well, and if I may, Jim Hivner, I'm going to, if okay, I'm going to be reaching out to you and sort of getting bullet points from you at some point in time to take to the the task force. So,
you anticipate, Tim, you'll have something to bring back to the full commission the September 13 meeting?
I'm going to make that happen. I will personally commit to that. And like I said, I had some unforeseen, issues come up, but we want to get this. We want to get this handled. And I know Justice Tarwater, I think, is getting a little heat from his fellow judges to wrap this up. And so we will move it on.
All right.
It's lukewarm, very lukewarm. Very lukewarm.
Lukewarm.
Not a lot of heat. It's a very comfortable temperature. You all don't worry about that. You all just do your work.
Well, and as you know, it's lukewarm. The pressure may be lukewarm, but as the justice knows, I think, and even intimated before, the various factions that are pushing both sides of this issue may not necessarily be lukewarm about it. So,
all right. Thank you, Tim. That'll take us, members, to item number 5, which was something that we deferred from the last meeting, Rule 42. Tim, is that within your purview as well?
that is within my purview. What I'm going to do on that one, rather than give you a lengthy diatribe about it, we've actually been waiting to hear back from the clerk's office on some of the logistical aspects of that. And I think, Elizabeth, don't mean to call you out, but last time we talked, you guys were taking a look. There were some concerns really just about the logistical and practical implications of making that. And when we began to look at the rule, there were numerous changes that probably needed to be made. And I think we sort of left that in the clerk of court's hands and Elizabeth to kind of give that some thought and get back with the committee on it. Is that fair, Elizabeth?
It is.
Great. And once again, Tim, do you think that's something that there'll be a recommendation on or not for the September meeting?
I'm not sure. I'll have to talk. That's when I'll have to talk with Elizabeth and Jim about, quite honestly.
Great.
We'll do our best.
Okay, I appreciate it. Do we have any other comments or issues or concerns to be raised before we adjourn? All right, let me just note that our next.
Mr. Chairman,
Sure.
Can you hear me? I apologize.
Yes, go ahead, Alex.
I wanted to raise the issue that I discussed with you on our last call. about the potential amendment to Rule 41G and just tell the folks who are on the criminal subcommittee that I intend to circulate. Can I do that now?
Please go ahead, Alex.
So Rule 41G relates to suppression motions, but it also relates to, and this is all in criminal rules, it also relates to the return of property that has been unlawfully seized. And before I was on the commission in 2017, the Supreme Court interpreted Rule 41G to not provide any opportunity for a non-criminal litigant to recover property under Rule 41. And the Supreme Court in that case recommended that the commission take up the issue and amend it to be consistent with the federal rule that allows, innocent third parties or non-criminal litigants to recover unlawfully seized property that has been taken pursuant to a search warrant. The commission, as far as I know, has not taken this issue up in the last decade. It's one that comes up most often in the context of civil asset forfeiture, where the government, police officers may get a search warrant, may seize property, but then may not choose to criminally indict or criminally charge someone. And that puts the sort of aggrieved party in an unusual situation where they have no legal means under Tennessee law to actually seek the return of that property. And so consistent with the court's suggestion in 2017, I've drawn up a proposed amendment that I want to circulate to the criminal subcommittee and get their feedback on. And then if we have a consensus, to present to the commission, hopefully at the next meeting.
Great. Thank you. Could you maybe just take 2 minutes, Alex, and summarize what the proposed amendment states in substance?
Yes. So in substance, it would create a new subsection under G. It would split 41G into two parts. Right now, our 41G is different than the federal rule because it includes both the return of property and the motion to suppress. And it would allow those two sections to have kind of subsections 1 and 2 under G. The only section that would change would be the section related to motion of property, and it would state that any aggrieved party can move the court for return of unlawfully seized property. And it would provide an additional sentence as to how the court should go about doing that and which court should do that. Fortunately, both of those provisions are in the federal rule and most corresponding state rules. Essentially, you would file the motion in the court where the search warrant was issued or where the property was seized, and the court must rule on it promptly, and it can take evidence as to that issue. And the last provision states essentially that if property is returned and there is an ongoing court proceeding, so for example, property of a third party is seized unlawfully, but it may relate to an investigation, the court can set protections to ensure that that property is available in the course of the criminal proceedings.
Well, great. Thank you. We look forward to discussing that at the September meeting. Speaking of which, I can just formally announce that our next meeting will be Friday, September 13th, 9 o'clock, using the same platforms that we're using today in person in Memphis, Jackson, Nashville, and Knoxville. And then anyone who can't attend in person, of course, you're welcome to attend remotely. Before we adjourn, does anyone have any other announcements or comments for the good of the order? Well, great. Seeing none, we are adjourned. Thank you all very much. We very much appreciate your being here and look forward to seeing you again in September.
Thank you.